can't. Stop. You need to listen to learn, not listen to reply.
On August 6, 2019, Freedom Fendler, a 22-year-old resident of Amado, Arizona, stopped at a Walmart in Sahuarita, Arizona, on his way to work at a nearby car dealership. He arrived on his motorcycle and entered the store without removing his riding gear. Full-face helmet, visor down, armored jacket, backpack. He was listening to music through Bluetooth headphones inside the helmet. 3 days earlier, a gunman had killed 23 people at a Walmart in El Paso, Texas. That context is not incidental to this case. It is central to how every court that reviewed it ultimately ruled. Inside the store, a manager approached Fendler twice, once from the front, once from behind, and attempted to ask him to remove his helmet. Fendler, listening to music with his view restricted by the helmet, did not acknowledge either approach. After approximately 10 minutes of shopping, Fendler checked out, sat at a bench near the entrance to organize his backpack, and was surrounded by several officers of the Sahuarita Police Department. The legal frameworks that apply here are the Fourth Amendment, governing arrests and searches, and Arizona Revised Statute 13-1502, the state trespass statute. Both will be applied directly to what the footage shows. When officers arrived, they had the following information: multiple 911 calls reporting a suspicious person, a store manager telling them he had asked Fendler to leave 5 or 6 times and been ignored, an active shooter context 3 days fresh, and a man standing in the store wearing a full-face helmet with the visor down and a military camouflage backpack. That is what the officers knew, not what actually happened, what they knew. This distinction is the foundation of everything that follows. Probable cause does not require officers to be correct. It requires them to have a reasonable basis for their belief at the time of the arrest, based on the totality of the circumstances known to them. Courts do not evaluate probable cause in hindsight. They evaluate it through the lens of what a reasonable officer would have concluded given the information available in that moment. Officers approached Fendler, ordered him to remove his helmet, and asked for identification. Fendler surrendered his identification without protest. Up to this point, the detention was almost certainly lawful. Under Terry v. Ohio, 1968, officers may briefly detain a person based on reasonable, articulable suspicion of criminal activity. Given the 911 calls, the manager's account, the El Paso context, and Fendler's appearance, reasonable suspicion clearly existed to investigate a potential trespass. Fendler then began answering questions, explaining he was on his way to work, that he had music playing in his helmet, that he hadn't heard anyone ask him to leave. This was his opportunity to dispel the suspicion. For a moment, it appeared he might. The officers questioned him about what he had purchased, where he worked, why he kept the helmet on. The answers were consistent and credible. A thorough investigation at this point might have ended the encounter with a trespass warning and no arrest. Then Officer John George intervened. What followed was not an investigation. It was a lecture. George told Fendler to pull his head out of his ass, accused him of scaring people, told him there were rifles outside waiting for a shooter, and ordered him to stop talking. This outburst served zero investigative purpose. It gathered no new information relevant to the trespass investigation. It advanced nothing. Under Florida v. Royer, 1983, the Supreme Court held that the scope of a detention must be carefully tailored to its underlying justification and that officers must use the least intrusive means reasonably available to verify or dispel suspicion. George's extended lecture almost certainly extended the detention beyond its legal justification. A court could reasonably find this a Fourth Amendment violation, not because George was angry, but because his conduct served no investigative function and prolonged the stop unnecessarily.
Dropping everything, man. Yeah.
So he said that he had music playing in his helmet.
I walked right up to him, just like I'm talking to you right now. Stood right there. So I knew.
Okay.
No,
Updated with MVD?
yes it is. I live in a motto.
Okay.
So did you see the manager basically walk up right to your face and ask you to take off your helmet? How'd you not see that?
I saw him talking, but he's got a headset on.
I'm standing
So.
right next to you. Right next to you. I came up and I said, sir,
I thought you were going this way. I didn't hear
I
you.
said, stop. I followed you halfway throughout the store.
So let me ask you something. What's the purpose of keeping the helmet on?
It's just faster to get to work, man. Like I said, I'm on my way to work.
Where do you work at?
Work at Jim Click, right
Okay.
there.
So you walk through the store. What'd you buy?
I bought a sandwich, a Gatorade, 2 peaches, a scrubber, I think 4 pens, and a toothbrush.
Okay.
That's it.
So you just
Basically
kept.
everything on here.
Let me see it.
I couldn't
So
find
you
a basket.
keep the helmet on. You walk around.
Yeah, I do that.
grab
at
all this
Safeway,
stuff.
I go to other Safeway. I go Fry's. Except for when I go to the bank.
I mean, he knows I know because I ride. He rides.
Yeah.
It's not. It doesn't take much effort to take it off, put it back on. I mean, it takes maybe like 5 seconds, 10 seconds,
It
if that.
doesn't, man. But I've never had any issues where anyone's like, take it off, or a sign saying that you need to have it off. And like I said,
That's why the manager asked you to take it off.
Like I said, I didn't hear him. I had music playing throughout the
Okay.
street.
You didn't see me? I'm standing right in front of you.
I saw you there, and then I saw you talk. But like again, you have a headset on, so
I can't put my hands on you to get your attention. I was standing
Oh, yeah,
right next to you.
I
Right?
didn't.
Just like I'm standing
I
here with the
didn't see
officer.
you come next to me.
I stood right in front of you, just like I'm standing here. I said, I need you to stop and listen to me. You totally ignored me and kept walking.
Sir,
I got
have
associates
music
that
playing,
were upset and concerned because you're walking around with a backpack with a helmet. Nobody knows who you are.
But I made a.
George also ordered Fendler to stop talking. In the 1987 Supreme Court case of Houston versus Hill, the court held that citizens have a First Amendment right to voice their opinions to or near police officers whether or not they are performing their duties. Ordering a detained civilian to stop speaking is government suppression of speech. It is not a lawful order. After George's tirade ended, Fendler went silent. He gestured that he would not answer further questions. Officer Rivera, the second officer, told a colleague he was contemplating arrest and stated the reason directly, especially the way Fendler was acting. The officers had initially decided to issue only a trespass warning, banning Fendler from all Walmart locations. That decision was reversed. Fendler was placed under arrest for trespassing. Officer Rivera also cited him for disorderly conduct. This is the moment the legal analysis becomes genuinely instructive. Fendler was arrested immediately after going silent, not for anything he said, not for anything he did physically, for exercising his Fifth Amendment right to remain silent after being lectured by a police officer. And yet, both the District Court and the Ninth Circuit ultimately found the arrest lawful. Here is why.
I'm concerned about the safety of my
I'm going to stop him
associates.
now, okay? You're an argumentative person, and I am not the person you want to argue with. You need to take
You
a
want his?
stand and you need to go like this and pull your head out of your ass, okay? Because you're walking around in a store hiding your face. There's shooters that go on all over the place. This man comes up to you and you want to play. You got a little Senate headpiece going on that you can't stop. You need to listen to learn, not listen to reply. You need to turn that little switch off in your brain that you want to run your mouth and argue every time somebody tells you something. Because this is disturbing the peace. You can go to jail and not go to work. So what's the choice you're going to make, hardhead? You're going to quit walking around businesses with a helmet on, scaring the hell out of people to where you got massive cops all over the place, rifles outside waiting for a shooter to come out? Laugh.
Yeah.
But that's where we're at. So pull your head out of your ass and quit arguing every time somebody tells you something. I'm telling you, look at what you're doing. You keep wanting to argue with me. I'm not the guy you want to argue with.
Wasn't trying to argue. I'm just
That's
trying
why
to
you
state
keep
my
talking.
point.
Stop talking.
Okay, fine. Cool.
Who went over
Do
register arrest?
you have his info?
Hold on.
I was gonna see if they want to trespass.
Yeah,
from here and
I
all
do
Okay, so officially being trespassed from the store, don't come back to Walmart. Come back to Walmart, manager, anyone sees you, you get arrested for that.
Yes, he is told.
And we don't have a picture taken with a helmet.
Well, you will when he walks out. It'll be on the camera when he walks out.
Thank you.
What's your telephone number?
Do I have to provide that, sir?
Yes, you do.
Alright. I gotta look it up on my phone.
And what else is in that pocket?
Your phone.
All right. Give me a telephone number.
Arizona's trespass statute, revised statute 1315-02, defines trespass as knowingly entering or remaining unlawfully on any real property after a reasonable request to leave by a person having lawful control over that property. The key word is knowingly. Fendler's defense was that he never heard the manager's requests. The court acknowledged this as a possible innocent explanation, but under established probable cause precedent, specifically the standard articulated in Yusefian v. City of Glendale, a Ninth Circuit case from 2015, the mere existence of evidence suggesting a valid defense does not negate probable cause. All that is required is a fair probability that the person knew their conduct was unlawful. The court found that probability existed. Officers had uncontradicted information from the manager. Fendler was still in the store when they arrived. His explanation that his music prevented him from noticing a manager following him across the store, approaching him twice, and asking him to leave repeatedly struck the court as potentially implausible, given that Fendler had also failed to notice 3 uniformed officers surrounding him until one stepped close and raised his voice. On disorderly conduct, Arizona Revised Statute 13-29904 defines the offense to include knowingly making a protracted display with intent to prevent the transaction of business. The court found that given Fendler's dress, manner, and the El Paso context, an officer could reasonably conclude he intended his appearance to be disconcerting and disruptive to Walmart's business operations.
I'm thinking about it, especially with the way he's acting. He asked him 5-6 times to leave, called him around the store.
I would say so. I'd say we lift the threshold. Why not?
So,
Especially the current behavior.
You asked him about all the leaves the store?
5 or 6 times. Walk right next to him, just like we're walking right now.
You're under arrest for trespassing. You were told to leave the store, and you didn't want to
You want me to
cooperate.
take my jacket off?
Nope, I want you to leave your jacket on.
Right now. Turn around, please.
Wait, which way am I turning, man?
This one. This one. Oh, there you go.
All right, you have the right to remain silent. Anything you say can and will be used against the court of law. You have the right to the presence of an attorney prior to question. If you cannot afford one will be appointed for you. Do you understand those rights? I'm going to take your silence as a yes. That's my finger that you can feel inside of each one of those, showing you have enough space that they're not too tight and binding. They're double locked, so they're not going to close up. Go ahead and walk. We'll search you outside here.
did you get the manager's info?
Yeah, I got his info.
Fendler's disorderly conduct charge was dropped by prosecutors. That matters. Prosecutors reviewed the evidence and concluded the charge could not be sustained at trial. But the lawsuit failed not because the arrest was right, but because the legal standard for probable cause is lower than the standard for conviction. Fendler sued under 42 U.S.C. Section 1983 for false arrest, malicious prosecution, and illegal search. In February 2023, the United States District Court for the District of Arizona granted summary judgment to the defendants. In April 2024, the Ninth Circuit Court of Appeals affirmed that decision on all claims. The Ninth Circuit's reasoning is the most important legal takeaway from this case. An arrest does not require officers to eliminate all innocent explanations. It requires a fair probability, not certainty, that a crime was committed. The officers here had the manager's account, multiple 911 calls, the active shooter context, and their own observations of Fendler's behavior during the encounter. That combination, the court held, was sufficient. Fendler demanded $250,000 in a pre-lawsuit notice of claim, a legal requirement before suing a municipality in Arizona. The town rejected it. He received nothing. On the illegal search, officers searched Fendler's backpack and person incident to his arrest. Because the arrest was found lawful, the search incident to that arrest was also lawful under established Fourth Amendment doctrine. The search produced nothing, but the legality of the search followed from the legality of the arrest. Officer George's conduct, ordering Fendler to stop talking, extending the detention to lecture him, was not directly adjudicated as a constitutional violation. The courts focused their analysis on probable cause. George's behavior remains legally questionable under Royer in Houston versus Hill. It simply was not the issue that determined the outcome.
Count this out. Got a like an RFBI wallet with currency attached. $100 bill apparently on the outside. Okay, 120, 25, 26, 27, 28, 29, and apparently 30. So $130.
Got it.
Three things to carry out of this video. First, probable cause is not the same as proof of guilt. Officers need a reasonable basis for an arrest, not certainty, not a conviction-ready case. The existence of an innocent explanation does not automatically defeat probable cause. If you believe you have been wrongfully arrested, the place to challenge that is in court, not on the scene. Fendler did exactly the right thing by remaining calm and pursuing legal action. The outcome was unfavorable, but the process was correct. Second, going silent is your right, but invoke it explicitly. Fendler chose to remain silent after Officer George's tirade. That was constitutionally protected. However, Fendler never verbally stated he was invoking his Fifth Amendment right. In practice, clearly stating, "I am invoking my right to remain silent," creates a cleaner legal record than simply going quiet. Third, context matters to probable cause in ways that may feel unfair. The El Paso shooting 3 days earlier was not Fendler's fault and had nothing to do with him, but it was part of the totality of circumstances courts used to evaluate whether officers acted reasonably. That is the legal standard, reasonable under the circumstances, not reasonable in the abstract. This case does not tell you that the officers were right. It tells you that under the law as it currently exists, they were protected. Those are not the same conclusion. If this breakdown helped you understand how the law actually works, share it with someone who needs to know their rights. We cover real cases like this every week. Like and subscribe so you never miss one.
Yeah, it's elastic.
Okay. It's like a kidney belt.
And then he's got the zipper to attach to his jacket.
Alright.
Have a seat. Keep your feet out.
Get the boots.
I was gonna have him take the boots off right now.
Pardon me?
I was gonna have him take the boots off.
Yeah, please.
Yeah, I was gonna have him sit.
Oh, gotcha.
So I'm not having to stand on one foot.
What does it say?
Yeah, sure. see your foot. Now the other one.
Down.
There you go.
Thank you. Thank you, sir.
Alright, kick your feet in.
I'm going to take his jacket off while we're all here. Because it's got to come off before he goes to jail.
Yeah, I was thinking about that. You think that'll fit through the booking window?
If not, they can send out one of the officers to take it from you.
Okay.
Booking window, the slot's about.
Yeah.
I think it will.
So, it might. It's got this patch. I don't know if it will. It actually has.
But we won't know until everything's on.
Yeah, it's got a back pad too.
Okay. It's got to come off.
Yeah. Step out. You gotta take your jacket off. Hey V, we're gonna take his jacket off, take your cuffs off.
Just keep your hands in place.
Lift the jacket up. I undid this one.
Oh, did you?
Yeah.
Oh, okay.
Either way, alright.
Thumb.
Thumb's cut. There you go.
Put my glasses up.
Sure. Over here. You're welcome.
Alright, you can have a seat back in there. Those prescription glasses, you need them to see?
Yes.
Okay. Perfect. Is there anything on you I might have missed?
I do have basketball shorts, but the pockets are empty, so just letting you know. It's your call.
You got basketball shorts, pockets are empty.
I got no reason to lie.
I'll just give you the information here. If you go down to jail, they're going to strip search you when you get there. If you have any drugs, any contraband, weapons whatsoever, when you're there, it turns into a felony, where here it's probably not. So if you have anything on you like that, you need to tell us now, because there you'll be going before a superior court judge instead of just the county judge.
I don't.
Okay.
Not on me, at least.
Okay.
I don't know about my backpack because I don't know. I remember putting in there. I don't think I have anything in there.
Yeah, thank you, sir.
Yeah, I'm gonna go through his backpack and all that stuff. I'm good. Thanks. Okay.
Can't think of anything else, right?
Not that I
Right.
think of.
His info, I'll drop his 27 in the call.
So real quick, I don't know if he explained to you or anything, but you're under arrest for disorderly conduct, okay? It's gonna be a class 1 misdemeanor, okay? You'll probably see a judge, the nighttime judge, so forth, and you'll probably be released. Alright? You have any questions on that?